Dr. Claasens is the former director of the Land and Accountability Research Center, and she will be speaking about the Ingonyama Trust judgment and the implications that it has for customary ownership and the communal land tenure bill policy approach. Aninka, over to you.
Thank you, Nolundi. So basically, Janet and Ster have provided examples of problems of tenure insecurity facing ordinary people, and they have talked about certain fault lines that run through and inform these problems. And I'm going to talk about how those fault lines are really exacerbated by the communal land tenure approach. And in the main section, I'm going to discuss the Ingonyama Trust judgment and illustrate that that judgment actually shows that the policy approach set out in the communal land tenure bill is unconstitutional, is in contravention of customary law, and it also is in contravention of statutory law, being the Interim Protection of Informal Land Rights Act. So just to start off with Janet and Ster's input, where they highlighted three key problems that inform current tenure insecurity. One is historical vesting, that process in 1986 where the apartheid government vested all the land in the former homelands in the homeland governments. The other is the problems caused by the power vested and exercised by some traditional leaders, and the last one being the serious failure of land administration. So Janet and Ster illustrate the dire results of that political vesting, where those political boundaries were overlaid on pre-existing land rights. Now, the communal land tenure bill defaults to exactly the boundaries created by that historical political vesting of land in the former homelands. It applies only to land in the former homelands. That's thereby setting up a segregated system of land rights throughout South Africa. But more than that, it provides that within the homelands, land will be transferred in ownership to either traditional leaders or traditional councils. So land belonging to ordinary people and occupied and used by them over generations will become part of title deeds held by traditional councils or traditional leaders. The communal land tenure bill also entrenches the power of traditional leaders in relation to decision making, and it provides no effective countervailing land rights or accountability mechanisms. And we've already seen that even prior to that bill being enacted, the actions of traditional leaders and the Ingonyama Trust is included here have led to wholesale dispossession in some areas, not in all areas, but in some areas. And then there is this terrible problem of the breakdown of land administration throughout South Africa, which I'm sure we're going to hear more about in other sessions. Basically, the communal land tenure bill has incorporated some kind of internal rights for occupants and residents because they know there's going to be a constitutional challenge. But those rights would need a very robust system of land administration to be recorded and to be endorsed and to be implemented and to be enforced. And there is no such system. Plus, those rights would always be subservient to the title held by the traditional council or the traditional leader, and the powers, the explicit powers vested in traditional leaders by not only the Communal Land Rights Bill, but the Traditional Khoisan Leadership Act. Now, the underlying assumption of both the Communal Land Tenure Bill and of the Ingonyama Trust is that communal land is free for the taking, that it's in the gift of the state to transfer to whoever it wants, to transfer to traditional leaders or to transfer to the Ingonyama Trust. And what the Ingonyama Trust judgment does is it resoundingly rejects that premise that communal land is vacant of any pre-existing rights. It uses the Constitution, it uses customary law, and it uses the 1996 Act IPILRA as a basis for proving that there are pre-existing property rights on that land. And it's those property rights that the 1986 homeland vestings that Ste and Janet referred to, and that the Communal Land Tenure Bill seek to obscure and to undermine. So at this point, I'm going to share my screen, because I'm going to discuss a whole lot of examples. I'm going to take extracts from the judgment. Let's hope I can do this. Yeah, there you are. Okay. So, but to give you some background before I do that, what happened with Ingonyama Trust is that the Ingonyama Trust decided to cancel records of all pre-existing rights, and those were mainly in the form of PTOs, and to tell people that if they wanted tenure security, they must take out residential leases. And if they didn't take out residential leases, they were threatened with eviction. And what that has done is it forced people to take out residential leases, and they ended up paying for land that they had occupied and owned for generations. And this is not a problem that is only taking place in KwaZulu-Natal. In many other parts of South Africa, we have traditional leaders demanding levies and payments for land that people have owned for many generations. So the court said that, how do I make this? Okay, slideshow.
Yes, thank you.
Okay, the court basically said that under customary law, each member of each class or community is entitled to an allotment under customary law. And once that has been allocated as residential or arable land, it is taken out of the realm of communal ownership. And it belongs to that particular family for generation after generation. That's reiterated in this second slide, where it talks about the inviolable nature of these property rights that belong to those families and pass from generation to generation. And it bases this judgment not just on customary or indigenous legal systems, but also on statutory law, that's IPILRA, and the Constitution. And it finds that contrary to what the Communal Land Tenure Bill assumes, and contrary to what the Ingonyama Trust insisted, that so-called communal land is full of ownership rights held by people in terms of customary law, in terms of constitutional rights, and in terms of IPILRA. Now, this idea, which is ignored by the Communal Land Tenure Bill and the Traditional and Khoisan Leadership Act, that customary rights constitute ownership, is not a new thing in South African law. So it's quite extraordinary that these bills are premised on the fact that this land is free for the taking. Because from the 1960s, Professor Alistair Kerr wrote textbooks about the de facto, the actual content of customary law, and showed it was ownership, both pre-statutory customary law and post-statutory customary law. We have even the apartheid government recognizing in 1991 that a whole lot of the different forms of land rights that people were forced to have under apartheid were discriminatory and must all be upgraded to ownership. That's with the Upgrading of Land Tenure Rights Act. So that is an acknowledgement that these underlying rights should have been ownership and were only not ownership because of apartheid. Then we've got Section 25(6) of the Constitution, which Ste read out, which confirms that anyone whose rights are insecure because of discriminatory law is entitled to tenure security, and there must be a law to give effect to that. But the only law we've got is IPILRA, which is a very basic bottom line protection dealing with the most basic element of property rights, which is consent against interference. And that was so basic because the Land Rights Bill was in the wings, about to be enacted, but never was. Then we come on to court judgments. So contrary to the way in which Parliament has acted in introducing legislation that ignores these underlying property rights, the courts, especially the Constitutional Court, has recognized these property rights. So you have the Alex Call judgment about Richtersveld, which found that customary rights to land were ownership, not like ownership, not akin to ownership, but they were ownership. And then you had the Tongwani judgment, which struck down the previous Communal Land Rights Act, which is basically the same as the Communal Land Tenure Bill. And although that judgment was a procedural judgment about how Parliament had gone wrong, not about what was wrong with what it did to land rights, it did warn that the Communal Land Rights Act trespassed in an area that was not vacant, that was full of rights. In other words, was full of customary law rights. And then we have the important 2018 Maledu judgment, which upholds IPILRA and the Constitution and informal rights in the face of this incredibly common assumption that mining takes precedence over everything in South Africa, this legal assumption that it takes precedence over everything, even the Constitution. Now, the Ingonyama Trust judgment goes further than either Alex Call or Maledu, because those talked about the community's rights, communal ownership, whereas Ingonyama Trust judgment talks about the internal customary law rights held by individuals and families, and it talks about who specifically has decision-making authority. So decision-making authority is an intrinsic component of property rights. You don't have property rights if you can't exercise those rights. And what is so bizarre about the Communal Land Rights Bill and about the Traditional Khoisan Leadership Act is that they try to take the decision-making component of land rights away from the holders and give it to traditional leaders. But that is consistent with their refusal to acknowledge that people have pre-existing property rights. So if you look at this paragraph 101 of the judgment, it talks about the rights of people in terms of customary law, and it talks about their rights to use land, to dispose of land, to erect a building, to let it, to transfer it, or to bequeath it, to give it, to leave it to your children. Now, those are all forms of control that the Ingonyama Trust took to itself through the leases policy. It took away all of those rights, all of which entail decision-making authority, and it gave all those rights to itself. Now, consent to stop deprivation is the most basic of property rights. You know, these other rights get added to it: occupation, to use it, to dispose of it. And basically, IPILRA protected that most basic and continues to protect that most basic of rights. And what this judgment really deals with is rights of occupation and use. In other words, rights to houses and fields. It doesn't really deal with common property rights, rights to shared land. And that is very, very important category of land, because that's often where the development takes place, on the grazing land or in the forests or whatever. And although that is beyond the scope of the judgment does make reference to the fact that just as people have strong and secure rights to residential and arable land, they also have strong and secure rights to commonage, and to, which is grazing, woodland, all those other things. And it reiterates, and this is from the judgment, the terms of IPILRA, which differentiate between processes of consent in respect of occupied and used land, in other words, houses and fields, and where land is held on a communal basis. And it says that where land is held on a communal basis, you need the consent of the majority of the people affected. Now, this is completely different from the idea that the chief can make those decisions on behalf of the tribe. So that what you've got here is the decisions are taken by the people who've got shared access rights. In other words, they've got IPILRA rights, not some bigger entity headed by a traditional leader. What the judgment finds is that the trust arbitrarily deprived people of their property rights. It says that its program of leases amounts to an arbitrary deprivation of the beneficiaries and residents' PTO rights, customary law rights, and informal rights or interest in the land. And it says that that deprivation of rights is not only in terms of customary law, but also the Trust Act, also PLAAS, and the Constitution. Because one of the key provisions of the Constitution is that there cannot be arbitrary deprivation of property. So what it means for the Communal Land Rights Act is, for the Communal Land Rights Bill, is that if the state were to enact that bill and to then transfer ownership and control of land owned by families to traditional leaders without expropriating their rights, it too would be guilty of arbitrary deprivation of property. So I think, you know, the Ngonyama Trust judgment really is a very, very stern warning to government about the approach that it's seeking to adopt with the communal tenure bill. Now, the question is, will this judgment turn the tide? Will it force government to actually recognize that people have got pre-existing customary law rights on this land that they plan to give to traditional leaders? Will it send the drafters of the communal land tenure bill back to the drawing board? And it's unlikely that it will, because the debate about those bills is not a debate about property rights. It has been completely dominated by a debate about the status and the powers of traditional leaders. And that debate about the powers of traditional leaders completely hides the property rights that are at stake. And here we see Judge Madondo saying in the judgment that it's sad to see Mr. Ngwenya, the head of the Ngonyama Trust, trying to say that this litigation is an attack on an affront on the institution of Ubukosi, rather than an exercise of people's rights to protect their property rights. And, you know, he talks about the fact that this case is not about the role and constitutional status of the king, which is what the Ngonyama Trust always tried to make it out. They tried to threaten the applicants in this case by saying they have insulted the king, whereas the judgment makes clear that all these people were trying to do was to actually enforce their property rights and protect their property rights from arbitrary deprivation. It's a deep irony that the traditional leaders in the Ngonyama Trust who are demanding these land transfers are supporting the idea of absolute ownership and title deed ownership, which is a Western construct, at the expense of any kind of recognition of customary forms of coexisting, long-established historical rights. So in a sense, they are using Western constructs of property law to trump the kind of tradition that they pretend that they want to uphold. So, you know, in a way, this is a very refreshing judgment. It's by a self-avowed traditionalist. Deputy Judge President Madondo calls himself a traditionalist, but he has cast customary law as a source of rights and of decision-making authority for ordinary people, and not as a blanket to obscure ongoing processes of dispossession. Now, it must be noted that leave to appeal has been granted. The Ngonyama Trust has applied for leave to appeal, and they've got leave to appeal, but only on very limited grounds. And in a way, we need this judgment to go to a higher court, because at the moment, it's only got the status of a judgment at the high court level. And, you know, it's actually beneficial that such an important judgment should be at a higher level. And that's what's going to happen through this appeal process. But in the meantime, all the processes that were put in place to defend people against the Ngonyama Trust have unfortunately been put on hold. So I'm going to leave us there. Tembeka will now lead us in a discussion about alternatives. And really what we have at this stage is we have a political trajectory by Parliament, which is all about appeasing elite interests. And we have a clear direction given to us by the Constitutional Court about how customary law should be upheld and land rights should be respected. And somehow we've got to break the unfortunate contradiction between the two so that we can move into an era where our policy, our land tenure policy, is informed by the Constitution and securing rights rather than appeasing traditional leaders and other elites. Thank you, Nolundi.